G'day everyone, and welcome to the third video for week 5 of our admin law course. We're still looking at the concept of natural justice. We know that natural justice involves the right to be heard and the right to an unbiased decision maker. We know that anyone who will be affected by a decision has the right to natural justice in relation to that decision. In this video, we look at the content of the hearing rule. Once it's established that a person has the right to be heard, what does that actually mean? What does it actually look like? Traditionally, we say that the hearing rule has 3 requirements. The person must be shown the material that the decision maker intends to rely on. The person must be given a reasonable opportunity to consider that material. And then the person must be given the opportunity to be heard. Let's go through those one by one. First, the person must be shown the material that the decision maker intends to rely on. This is super important because if you don't know what the evidence is against you, then how on earth are you going to have an opportunity to respond to that evidence? In a case called Kanda against the government of Malaya, a police inspector was being dismissed and he wasn't told the basis of his dismissal. He appealed all the way to the Privy Council, where Lord Denning said, if the right to be heard is to be a real right, which is worth anything, it must carry with it a right in the accused man to know the case which is made against him. But what does that mean? What does it mean to know the case against you? The court has never really been clear about this for good reasons. The closest thing we have to a rule is a statement in a case called Commissioner for ACT Revenue and Alpha One, where the court said that the person must be given sufficient information to understand the case against them and to know those things which the decision maker intends to take into account. Still not all that helpful, but it's hard to see how the rule could be made any clearer. Administrative decision makers make millions of decisions a year under thousands of pieces of legislation, and each of those decisions will be, in some sense, unique. Any attempt to specifically set out what needs to be provided would be absolutely doomed. There's just too many variations. The general principle is that if the decision maker sees it, then so should the person who's entitled to natural justice. There are limits, but none of them are very surprising. Secret information obtained from law enforcement or intelligence sources is unlikely to be provided. Government agencies are still required to protect the private information of people unless there's a proper reason to release that information. So materials provided by the decision maker might be redacted to black out the private material which can't be provided. In general, though, the basic principle is that if the decision maker has regard to a piece of information, then that information should be disclosed to the person affected by the decision. Next, a person must have a reasonable opportunity to consider that material and respond. What's a reasonable opportunity depends on the amount of the material, its complexity, the potential consequences of the decision, the urgency of the decision, and any factors particular to the applicant. So, for instance, a person with a vision disability or a person who does not speak English might require more time than a person without those circumstances. In a case called Communications Union against Abbey Group Contractors, a Fair Work Commission matter was adjourned for just 76 minutes so that the union could consider 350 pages of new evidence. The evidence was complicated and required detailed analysis. The full court of the Federal Court found that the hearing rule had been breached because nobody could be said to have had a reasonable opportunity to respond to 350 pages of the detailed material in just over an hour. So let's say that all the right information has been provided and the person has had a reasonable opportunity to respond. They must then have the opportunity to be heard. A couple of things about this. First and foremost, in the modern world, the right to be heard is usually actually a right to be read. Most of the time, the person will provide their response in writing. Every now and then someone will get cranky about this because they really wanted to stand up and have their say, but there's no actual right for them to do so. There's also no actual right for a person to be represented in this process by a lawyer. Now, obviously, nothing can stop the person from engaging a lawyer and seeking their advice while preparing their response. However, ultimately, there's no actual right for the person exercising natural justice to have their arguments put forward on their behalf by a lawyer. This was the issue in dispute in a case called Keynes and Jenkins, where a person was ousted from a union position and complained that they didn't receive natural justice because when the union management did hold a hearing in person, they required the union officer to answer the allegations personally, and his lawyer was not allowed to participate. He challenged that, and the court confirmed that there was no right to legal representation. There are some other common sense boundaries around the right to respond. A decision maker would be quite justified in refusing to consider a response if it was completely irrelevant, or if it was presented in objectionable or abusive terms, or if it was otherwise improper. Finally, whilst I've presented this material in terms of distinct elements and rules, remember what the High Court said in WZARH, that case we met in the last video. They said that the real question for natural justice is what is required in order to ensure that the decision is made fairly in the circumstances, having regard to the legal framework within which the decision is to be made. What this means is that you can't simply look at a decision and identify that a particular document wasn't shown to the applicant and therefore argue that there was a breach of procedural fairness. You have to be able to show that the defect, if there was a defect, resulted in the decision not being made fairly. Of course, the hearing rule would be kind of pointless if the decision maker had already completely made up their mind, wouldn't it? If the decision maker has confirmed their decision and has no intention of changing their mind, well then the hearing rule won't help you at all. So in the final video this week, we're going to turn to the second limb of natural justice, the bias rule, which says that a person is entitled to an unbiased decision maker.